Okay, guys, welcome back to the Restart Speaker Series. If you're not familiar with our show, we provide all sorts of insightful and inspirational live interviews of guests like today's guest, Joe Kromholtz, and a Restart Small Business Guide to Thriving During Chaos. That's available on Amazon for $14.99 in paperback and $9.99 in the ebook. Today's sponsor is Fuse Creative. Fuse provides graphic design services for small business and medium-sized businesses and startups. They do all our graphic design for our shows, our books, our social media, so I can't recommend Fuse enough. Their URL is fusecreative.co. All right, so let's get into the meat here. Today we're going to be talking about intellectual property, patents, trademarks, and copyrights. You are going to get a crash course in intellectual property. And today's guest is Joe Kromholtz. Joe is a partner at Ryan Kromholtz and Mannion. They are an intellectual property firm based in the Milwaukee area. Welcome to the show, Joe.
Thank you very much. I really appreciate being here.
So, Joe, tell us a little bit about your personal background, where you're from, law school if you want, how you got into the practice of intellectual property law, and then we can talk a little bit about your firm.
Sure. Well, I was born in St. Louis, Missouri, but I grew up in Wisconsin.
Okay.
I attended Carroll College in Waukesha, Wisconsin, and studied chemistry.
Yep.
And then I worked in plastics for a little while, and then I went to Marquette University Law School, where I obtained my law degree. While I was at Marquette, a professor there told me about patent law. I was able to get a clerkship with a very fine attorney by the name of Alan Wheeler, and I eventually was able to take over his practice, and that is what became Ryan Kromholtz and Mannion. We now have about 7 attorneys, all functioning through this current COVID crisis. And we focus on intellectual property law. You can call us at 262-783-1300, or you can find out our information at our website, which is rkmiplaw.com.
Great. All right. Great foundation information there. So let's just dive in. I mean, one of the questions I get, most frequently especially from entrepreneurs is, I have this amazing idea and I need to get a patent. And a patent they use generically to describe copyrights and trademarks. They don't understand the different types of patents. So give us just an overview of what patents are and how they work.
Okay, patents protect ideas. Okay, so if you have an idea for a better machine, a better method of doing something, a better composition of matter, that's where you would get your patent protection. And patents are, the classic patent is the what we call the utility patent, and the utility patent has a description of the invention in it, and it finishes with a definition of the invention, and we call that the claim. The claim is 1 sentence long. Sometimes it's a really long sentence, and that describes your invention. And the trick is to say what's sufficient and necessary to describe your invention and nothing more. And in order to obtain a patent, you have to file your application with the United States Patent and Trademark Office and go through a negotiation process probably with a patent attorney like me, negotiating for you. It's called the prosecution of the patent, and it takes 3 to 5 years sometimes for these things to issue. It can be quite a long process, but in essence, a patent is the right to exclude other people from making, using, or selling your idea. So the patent covers the idea.
Can you talk about the difference between a design patent and a utility patent?
Sure. A design patent is, well, we've talked about just now what a utility patent was.
Right.
A design patent covers only the design shown in the drawings. It's basically, you say, I claim the ornamental design shown and described herein in my drawings. You have one claim, and it's to that design. Now, design patents are limited because they're limited to exactly what's disclosed in the drawing. But Apple, for example, had a design patent on the original iPhone, and that proved to be a quite lucrative patent because the brick sort of shape was not the only shape you could elect to choose, and it became an important shape to use.
Right.
And you can always look that patent up if you want sometime. Actually, I probably have it here somewhere. I could dig it out if you want to look at it.
So in general, do you recommend that people go straight to a utility patent because it's much more broad because it is process and not a product, or both, or how does that work?
Well, we're just going to take something simple. Say you're making a lamp base, okay, and you're going to start producing lots of lamp bases. I would say, do a design patent for that because you're protecting the ornamental design as shown and described. If you have a process for making the lamp base, then I would say you'd want to look at a utility patent. Or if there's something mechanically interesting about this lamp base and the way it functions that no one else has, then use a utility patent. Obviously, the utility patent is more involved. It can give you greater coverage for your invention and your idea. So from that standpoint, it becomes a discussion with your patent attorney because these things are fact intensive. But I would generally say a utility patent is the way to go.
So in the lamp base example, I might have tell me if I'm wrong, a design patent on the base, but I might have a unique injection molding process. So in that case, should I file a design patent and a utility patent, or do you do one or the other?
Well, obviously, as long as we're having this theoretical discussion and cost is no object, I would say do both.
Right.
Okay. Because the injection molding process may be critical. Because let's say that someone changes the design, well, they don't infringe the design patent anymore, but they are still using that injection molding process, and your goal is to exclude as many people from making, using, or selling your invention as possible.
Okay, great. So let's talk. You talked about that 3 years, which is freaking out some of the people that are watching. So let's talk about provisional patents, what they are, how they work.
A provisional patent application is available under the statute. They have a much lower filing fee. You still have to meet the basic requirements of a patent, except you don't have to put in definitions of your invention, what we call the claims.
Okay.
You can file that with the patent office, and that's sort of putting your flag in the ground, saying, as of this time, I came up with this invention.
Right.
You then have 1 year from that date where you can then file or formalize it into a formal patent application if you want. The provisional process is quite nice in the sense that it shows investors that you're serious about pursuing this, but you don't necessarily have to invest as much money up front in obtaining that patent. Okay. And therefore, you don't have to worry so much about confidentiality. Now, you do have to be aware of your deadlines and so on, but the provisional application goes away after 1 year if you don't do anything. It's not examined.
All right, so let's bounce into trademarks and service marks. Tell us a little bit about the what and the why.
Well, it's trademarks and service marks are basically the same thing. A service mark is just a trademark, but it usually applies to a service. So, like insurance, for example, like a good neighbor. Is a slogan of a company that would probably be a service mark in the insurance industry. And now, whereas trademarks traditionally are on products, Coca-Cola, Kodak film was a big one back in the day when people used film, and so on. So they both function in the same way. It's just slightly different terminology. The law that enforces them is the same law, and so on. But a trademark is simply an emblem or a word that you use to identify your product so that the public knows that it's a product coming from a particular source of a particular quality. I'll say it that way.
So if I have a service, so let's say it's a consulting service,
Sure.
I would put the SM up there. My understanding is it's not registered yet. I would register it and pay the $300
Right.
or whoever, and then I would change that SM to an R. Is correct or incorrect?
When you get the issued registration, you can then put the R in a circle. And before that time, you just put the SM, which just indicates that you're treating it as a service mark.
Yep.
The important thing to remember about trademarks is that they derive their rights essentially from use. You are allowed under the federal statutes to file what are called intent to use trademark applications, which give you an effective use date from the date of filing, once the actual registration issues.
Okay, so let me go back to my training example, because I'll do training for companies, for example.
Sure.
So let's just say it's called Dave's Training. You wouldn't call that because that's a horrible marketing mistake. But let's say it's Dave's Training. I put SM up there, and someone uses. Well, gosh, we're getting into copyright stuff here, so I got to be careful. Let's say someone tries to use that name. Could I file against them, or does it need to be registered?
No, it doesn't need to be registered. You can bring an unfair competition action. Usually you bring it both under state law and federal law. Section 43 of the Lanham Act deals with unfair competition. You would bring that sort of an action. It would depend on, let's just say you could bring the action. You would have a federal and state cause of action. You don't need to have the actual registration. Your proofs would be different. You'd have to, you wouldn't have certain presumptions that a federal registration gives you.
Gotcha. And so why bother going through the process of registering it if I could take action against someone just by putting the SM, creating a service mark for it?
Oh, because once you have a federal registration, then, use eventually becomes presumed. Eventually it cannot be attacked for being a generic. Sometimes it's very hard to attack it on the basis of, let me rephrase that. You can always attack a mark for being generic, but you cannot always attack it for being descriptive.
Gotcha.
And these become very formidable defenses.
Right.
And obviously, if you look at any large company, they register their trademarks, they protect their trademarks, and quite frankly, if a mark becomes sufficiently famous, people borrow against it.
Right. And my understanding, with one of my companies, I think, was it only $300 to file, or am I way off on that amount?
I believe the current filing fee is around $300 bucks.
Okay.
I always, I'm old school. I always look up in the latest fee sheet before I tell it.
Right.
But I believe it's around $300. But that's the government fee.
Right.
And obviously your lawyer will charge you a fee. We usually just charge a flat fee because we have several conversations before we get to that part in the application.
Gotcha. Okay, so lastly, let's go into copyrights. Let's talk about what they are, when you use them, and why you use them.
Okay, a copyright, we talked about patents before, protecting the idea. A copyright protects the expression of an idea.
Right.
Let's just talk in broad brush. Let's say like the horror novel is an idea, the idea of having horror novel. You can't copyright all horror novels, but Stephen King can copyright, The Stand, which is the book he wrote, which is the expression of a story in that genre of horror novel. And so that specific expression can be copywritten and protected. Now, in view based on recent Supreme Court decisions, you need to have that copyright registered if you choose to enforce it. But the copyright exists the moment your work is fixed in a tangible medium of expression.
Okay.
So when the copyright is fixed in that tangible medium of expression, pen to paper, for example, the copyright exists. Just your ability to enforce it is predicated upon your registration
Right.
with the U.S. Copyright Office.
So we'll go back to my training. When I create content, I will put the little C at the bottom, right? And tell me if I'm doing this incorrectly. I'll put the little C at the bottom. Sometimes I'll write the word copyright. I put the year, and so the company I use is Startup Guides LLC. Am I doing that correctly? So I would put that at the bottom of each
Right.
slide.
The little C in a circle is the proper notice.
Right.
You don't necessarily need the word copyright. You can but saying the word copyright doesn't hurt.
Right.
And then putting the date and then the name of the author or the name of the owner is totally a correct way of doing that.
And the date is what I use, and I could be doing this incorrectly. I just put the year, not the date, the specific day.
Everyone just uses the year. The year is fine.
Okay. And if similarly, so let's move off of my training. Let's talk about websites. At the bottom of my websites on each page, I put copyright there. Good idea, bad idea. Can it be enforced?
I think it's a good idea. Okay. I think, look, if you don't ask, you don't get. If you don't enforce rights, you don't have the rights.
Right.
Therefore, if you're trying to protect whatever's on there now, the debate can be, was this copyrightable subject matter or not?
Right.
But you listed as with the word copyright on there. Maybe it is, maybe it isn't. But if your view is this is legitimately copyrightable subject matter that you created, then I would put the word copyright on there. Now, if you're not that you would do this, but if you were taking someone else's picture and putting the word copyright and claiming it as your own, that could subject you to legal liability because you are misrepresenting the origin and the ownership of that, and you are in fact taking someone else's property.
Yep.
So remember, we're focusing on things that you created.
Right.
Okay.
Yeah, so I reflect back to when I had an ad agency and we built out a website, and we use a content management system so the client could change the content after the fact. And we're really careful if we were using images, they were photos that we took, or they were free images, right? There was no licenses on them. And one of the things that our client did is they changed up a page and they pulled an image off of Getty Images, which is done all the time, slammed into the website, and we got a very nasty call from Getty Images about how we were violating their copyright. Do you want to talk a little bit about that? Have you seen that happen much, especially with people, in their marketing?
Sure. Yes, and don't do that. Okay.
Right. Okay.
But I mean, the short answer. That's the short answer.
Right.
Or you call up Getty Images and you say, "Hey, we have this image. What would it cost to get this?" And they may be very nice and say, "Oh, that image. I'll charge you $25, and you have this license to use it." Or they could say, "Well, that image is very special, and it's a very expensive image to use."
Right.
But you're better off asking first.
Right.
If you misuse a copyright, a company like Getty, I'm sure registers.
Yeah.
If they have registration, they can seek statutory damages, and even negligent use can. I think the minimum is $750. So you don't want to mess around with this.
Yeah, and Getty. They tend to do a really good job, not just with the quality of the photo, but they could be very specific images. You might say, look, I need a picture of a software developer sitting in front of the U.S. and Patent and Trademark Office, and there's sun behind them. Now, that's a ridiculous example, but when you need really specific content, you can get images like that, but you are going to pay for them. All right, we're almost at our 20 minutes. Biggest mistakes that you see clients make? I mean, and I'm guessing this is they've done it themselves, and they've come to you and they've said, "I've got a problem," or maybe they don't realize they have a problem. What are the biggest traps, the biggest mistakes that you see people making?
Well, I think it depends obviously on what you're trying to do, but the biggest mistakes I think that occur, at least in the patent field, deal with confidentiality. Everyone wants to go out and develop their product,
right?
But you have to understand that almost the United States is unique in that you can make an offer to sell your product, you can disclose your product, but you need to move forward and file within a year of doing that, or you'll never be able to obtain a patent on it. So keeping track of the time or the timing, some people, they start by getting out there, developing the product, and then they're shocked that somebody would just take it from them and start manufacturing it. And if you have no patent, well, there's nothing to stop them. You can't exclude them from doing it.
Right.
So I understand if you're a startup, you don't have a lot of money. Well, maybe you file a provisional application, you plant your flag.
Right.
Not everybody wants to get signed confidentiality agreements.
Right.
In fact, many companies don't want to do that. Right. So my point of view on it is file a provisional application, go out, start marketing your product, understand that until you have an actual issued patent, you probably don't have any ability to exclude somebody else. Right. But at least you're in line and you're moving forward, because now in the United States, it's the first inventor to file. It's not the first inventor. So you need to charge the patent office with your invention and get yourself on file. With copyrights, I think the biggest mistakes I see are that people don't either register their copyright right away, or they are not careful when they take things off the internet and they get into trouble. Right. We already dealt with the photograph issue. My point of view is if you have things that you want to protect, you should register it. By registering right away, you can get yourself in line to make demands for statutory damages, because it may be that the person infringing hasn't really caused you that much harm, but you still want to be able to ask for this statutory damage, which can, for a negligent act, can range from like $750 up to $30,000, I believe. And if they did it on purpose, up to $150,000.
Okay. All right, great. All right, we've got questions rolling in here. Let's see. I think we hit Charlie's first question. What's the fastest that's most overlooked? How much impact? So I think, we talked a little bit about damages. Let me go back a step. So let's say I've protected my idea with a patent. I mean, obviously, if someone's violating it, it's not as easy as just getting on the horn and say, hey, you violated our patent, right? This is where people like you come into play. So let's talk a little bit about that. Let's say someone's violated my patent and I call you up. What's the next step?
Well, let's assume it's a straight up infringement. You have different courses of action. I assume your competitors in this industry, sometimes calling up your competitor and saying, you violated my patent, please stop, is a good first step. Now, when
you say call, we're talking usually something written, right? A cease.
Well, you would send a cease and desist letter. I've had clients who've been quite angry and have called someone up, and words have been exchanged, and then you find yourself in the courthouse quite quickly. And it's usually with countersuits back and forth. But the bottom line is, let's just talk simple.
Right.
You have a patent, someone's violated your rights, you can go to court and sue that person under the Patent Act if they've acted egregiously, and it's a case that the court deems exceptional. You can even force that other person to pay for your attorney's fees. That doesn't happen all the time, but it's available. Also, if they've behaved badly and done it on purpose, this infringement, because you can infringe patents totally without even knowing the patent existed. But if you did it on purpose, the court has within its discretion to triple the damages. So this is why you see Apple and Samsung fighting each other, and then they get, let's say, like a $500 million judgment. Then the next argument is over, well, I'm sure Apple is there saying Samsung did it on purpose, they're nefarious, they're horrible, or whatever they want to say. and they're trying to ask the court to triple the damages and then award them all their attorney's fees.
Right.
So now those guys have lots of money to do that. Usually in the smaller world, go ahead.
It's very arbitrary determining what those damages are, right? I mean, the easy one would be, look, you landed 4 deals and the deal's value was $100,000. But how on earth do you come up with that amount as to what those damages are?
You would hire an expert in most cases,
Okay,
who would then be able to look at the other one guy's sales, the other guy's sales,
okay,
and then depending on the type of situation, for example, if there are non-infringing competing products, you would probably be talking about a royalty rate being set.
Right.
If there are no non-infringing products available in the market, then you would be talking about lost profits,
right,
which can be much higher.
Okay. Yep. All right. We've got another question. So this was just a verification question that you can indeed, you'd put a label at the bottom of your website and you'd have copyright, the year, and the name of your company. So in my case, it would be copyright 2020 Startup Guides LLC, right?
Right. Assuming the company owns the copyright. Yeah.
So now my next question, so let's say this is 2020, 2021 rolls around. Do I need to update that date each year or not, because that was the kind of the date of origin?
You always want to use the date that you created the work. Okay. Because copyrights have a lifespan. A work for hire now, I believe. Well, in the old days, it used to be 75 years. I think they may have upped that. In the back of my mind, I'm feeling like it's now 95 years, but I'd want to go look at the statute.
All right.
A lot of these big companies petitioned back in the 90s to have copyrights extended, based upon the fact that a lot of their product was developed in the 1920s.
Right. Okay. So I think the other important point to make is copyright is very different from a privacy policy, right? Which should be used on your website, especially if you're collecting information. Do you want to talk a little bit about the difference and the importance of privacy policy?
Well, a privacy or confidentiality policy, you really should lay out on your website what your policies are. So when people come in, are you using cookies? Are you collecting information from those people? Internationally, which you go everywhere, you need to at least put people on notice at a bare minimum. Hey, we use cookies to enhance our service or whatever, i.e. we collect information about you.
Right.
Do you accept that or not? And you need to be able to say these things. Rights are becoming more important, mostly in Europe. And if you're dealing with any of that overseas, I can find that out. I liaison with a lot of European intellectual property lawyers, so that gets into a fairly complicated area. But the short answer is yes. Have a privacy policy. Use that policy to inform the users of your website what their rights are and what you're doing.
Now, by default, well, tell me if I'm right or wrong. By default, is the presumption that if you have the privacy policy and the person's using the site, that they've agreed to those terms and conditions, or do you need to have them accept that privacy?
I would have them physically click and accept those terms and conditions.
All right. Okay.
You see it. I don't know if anyone's gone like to the Guardian or whatever. Hey, we use cookies. Do you accept? And you click accept.
Okay, I've got a last couple questions here. The label you talked about when you are waiting for the copyright. So when you're, actually, I think the difference is we're talking about copyrights versus the trademarks, right? So on the website, I would never need to convert that copyright to something else, correct? I mean, the copyright is what it is. I think they're referencing the service marks and the trademarks before.
Oh, I see we're talking about. Okay, two different things. All right.
Yep.
Copyrights protect the expression of the idea. So copyright would probably be protecting your text, your images, and so on. The trademark would be could be a short slogan. It could be one word. We'll throw out a name of a beer, Budweiser, for example, or something like that. Which is a famous trademark, and obviously put to identify their beer having the quality that it has, and so on. You don't put the registration symbol on a trademark unless you actually have an issued registration. That's why you use the little TM before you have the registration, and you use the little R in the circle after.
And TM for products and SM for services. Yeah,
and if you make a mistake and you put TM after a service, it's not the end of the world. You're just doing that to convey the information.
Well, this was fantastic. We provided, we don't tell other institutions this, but a semester's worth of intellectual in 30 minutes. That might get me fired. But anyway, so no, all kidding aside, this was a
we're a little paused right now. Okay, there you are. Okay.
So actually, the other question that's come in, we'll kind of put that in the show notes. And if people want to get in contact with you, Joe, again, and they've got questions, how can they do that?
Yeah, you can call me, Joe Kromholz, at Ryan Kromholz and Mannion. The phone number is 262-783-1300. And you can contact us also through our website at rkmiplaw.com.
Okay, fantastic. Again, great interview. What a lot of meat here, folks, today. Again, thanks, Joe, for your time. And have a good day and be safe out there, everybody.